Let me begin thanking Catherine and Rachel from the Australian IUCN National Committee and my old and dear friend, Professor Rob Fowler, who is the convener of the panel, for the invitation to speak to you today. I regret that I'm not able to fly all the way to Brazil for this event. One would say, well, this is too far for one-day event, but what an event. I think what will be discussed today in this meeting is something that is very important, not just for Australia, but for the whole world. Because frankly, I don't see this type of sitting together and thinking together around environmental law, looking at what we have and coming with a study so comprehensive and so robust as this, something that can be used by policymakers, but especially by legislators. I was really impressed with the document. And I would begin with the title that you gave to this symposium. The title is Better Laws for a Better Planet. This is magnificent because it shows that laws, one, can play a role in the betterment of the planet or in the relationship between us humans and the planet. But second, also quite relevant, that the laws that we have, although they have improved what we call environmental quality, those laws can become dated. Often they are important for specific issues that were present at the moment that they were drafted or approved, but not to new issues. For example, laws that were drafted 30 years ago, of course, could not address issues like climate change. So I think this type of exercise is necessary not just in Australia, but everywhere in the world where environmental law has played an important role in protecting the planet and the foundations of life. In respect to the results of the panel's work, and there are so wonderful members of WCL in this panel, and I will not list them, so please understand that I only have 10 minutes, but I could say that at least 10 of those members of the panel are also part of the WCL family. In looking at the document itself, I would like to spend a couple of minutes just discussing or highlighting two of the several ideas that are listed there. Namely, idea number 2, design principles for environmental law. And the next idea, idea 3, directing principles to guide decision-making. I think it's very fortunate that the document at the very beginning starts with the notion of environmental law principles. Because if we have the principles right, for people like me, a judge, things are less difficult. Even in cases when the more sectorial legislation or regulation is not as good or has lacunas, it omits. But if we have the principles, this can guide judges in reaching results that better protect the environment. In idea number 2, the authors of the document captured the notion of the principle of non-regression. This has become absolutely crucial, not just at the international level, for example, in the climate change debate, countries dropping out of the treaty, but even closer to us in respect to domestic legislation. And in federal states like Australia and Brazil, at the federal level and at the state level. So we cannot backslide on what we put there to protect the environment. It doesn't mean that we are not tying the hands of the legislators, but saying, look, if you want to change this, you can do it. But at the end of the day, at the end of the legislative process, the environment should not be in a worse position than it was before. This applies to legislation, but also it applies, for example, to things that are very close to us, the conservation family, like protected areas. You can reduce by 20% the area of a national park, but then you compensate with 20% better quality, more pristine area, or even perhaps the double of the area that you degazetted. I think that's the term that you use in common law countries. But even more interesting from my perspective are the set of principles that come in idea number 3. Because there, I think it's where the authors of the document wanted to include what we are calling these days emerging principles of environmental law. And here it's where perhaps I would offer a couple of suggestions, although I know that the document is finished. Because that in comparative environmental law, and especially within the judicial community, the principles that we are discussing, and in fact we have adopted in a number of documents, including the IUCN Rio Declaration, but also the Brazilian Declaration during the 8th World Water Forum, the Judicial Declaration on Water Justice. We judges have come to propose, and we propose for ourselves, but of course to legislators as well, that environmental law should be guided by the principle in dubio pro natura. So this is an emerging principle, but a very strong one. Second, we judges have agreed globally that property rights play and should play an ecological function, in addition to the economic function or to the social function that many countries recognize in their constitutions. So we call that the ecological function of property rights. And this is crucial in understanding the causes of environmental degradation and in addressing those causes of environmental degradation. I stop here, again, congratulating all the drafters the many hands and minds that were involved in this exercise. As chair of the World Commission of Environmental Law of IUCN, we have achieved a lot in the past few years. We were able to help the establishment of the Global Judicial Institute on the Environment. It's just been registered in Geneva, with the Secretariat being established in Nairobi at UN Environment, and we are about to launch the Global Institute of Prosecutors for the Environment. So this is the new baby, so to speak, of the World Commission on Environmental Law. Again, congratulations. This is an exercise, as I said at the beginning, that is important to Australia, but more than that, to the whole world. Thank you very much.